Okay, good evening and welcome everyone to Wednesday evening's seminar, where we will be looking at further construction essentials, in this case, extension of time. And this is led by Richard Silver, Senior Partner. And as usual, if you have a question, Richard is only too happy to address. Please put your questions in the chat or Q&A tools in the bottom toolbar, and he will get to as many of those as he can at the end. And indeed, if there's something specific you wish to ask him but don't wish to do it in an open forum, please feel free to contact him directly, Richard Silver at silverllp.com. So without any further ado, Richard, the floor is yours.
Thank you, Julie. Good evening, all. For those of you who have listened to my seminars in the past, you'll be aware that apart from being a lawyer, solicitor barrister, I am also a construction professional, having held roles as Chief Surveyor and Construction Director, and am at the moment a panel adjudicator dealing with disputes, amongst others, on extensions of time. As I think I said only last month, I've been involved in various projects in different capacities, QS, contracts manager, so on and so forth. But unfortunately, not one of those ever finished on time. And hardly surprising, of course, it was not my fault, and we claimed a full extension of time. And that's what I've found always to be the case, that where a job falls into delay, generally the contractor will always seek an extension of time, not least to avoid liquidated damages, but also potentially to seek to recover loss and expense. And what we're going to look at is the mechanics under the contract of seeking to establish and obtain the award of an extension of time. And the start point is that one must always look at the contract. Different mechanisms apply under different contracts, but what they should have at least is a mechanism within the contract for extending the date for completion or for the section, and thereby a date. Where you've got no date stated in the contract, and it does happen, time will be at large, which we'll identify in a moment, and you have a reasonable period to complete. But different contracts have different mechanisms for extending the date, and I think I should just address that now. So under the JCT forms of contract, it's fairly simple. If there is a delay, which is a relevant event, and causes the completion date to be extended, you prove what that delay is, and you hopefully get awarded that period of extension of time. So the award should reflect what was roughly the delay. So put simply, you finish 6 weeks late, it's because of an employer's failure, you hopefully get awarded 6 weeks extension of time. I spoke with a client just today, and they sought to argue with me that, well, surely the award should be considered at the delay the event occurred and when we gave notice. So we've had an event today, we've assessed it will be 6 weeks, so you should award us 6 weeks. The fact that it didn't cause us any delay is irrelevant. I'm afraid that's not right. You will be awarded what is the reasonable extension of time that you're entitled to under the contract based upon what actually went on, not on some theoretical basis. Now, there is an argument to say that the architect, employer's agent, has 12 weeks to consider, so you maybe should be putting yourself in the position that he would be after 12 weeks, or from receipt of full particulars. But generally, if you're involved in an adjudication, arbitration, or a litigation, what the adjudicator, arbitrator, judge will do is to look what actually happened and assess what the actual delay was, and thereby your entitlement. Now, there is an exception, and you'll know from the seminars I've given in the past, the exception nearly always seems to be the same. It's the NEC. The NEC mechanism is worded completely differently. It deals with compensation events, and what it says is, in assessing the delay, it is the difference between the last accepted program and the current accepted program. It does not refer to the completion date stated in the contract. So the completion date, what's shown on the last accepted program, could either be before or after the date stated in the contract. But it is that date that you monitor against. So if you have a contract that shows you finishing 1 week early, that's what's shown on your accepted program, and then you issue a program with your quotation, and that shows you finishing on time. Should that quotation be accepted, you get a week's extension of time, even though you're going to complete on time. The second point is it's not based upon what actually happened. It's based upon quotations and programs projecting the delay. Now, it's my experience that all too often quotations are either not issued or not accepted, or programs are not issued, or there is no accepted program. So the question then happens, well, what happens then? And it is that situation where, again, your award is likely to be reflected in what actually occurred. There will be retrospective delay analysis, and it will be looking at what was the actual date of the completion date. Let's press on. Now, more often than not, with the exception of the NEC again, programs are not incorporated into the contract. And all we generally have is a start date and a completion date. NEC, as always, is different. It provides for a program to be included in the contract data, or where there isn't one, for one to be issued within 2 weeks generally thereof. Under the JCT, there is an obligation to provide a master program, but it is not definitive in the contract what should be included on that program. Now, as I said, it is not unusual for there to be no date stated in the contract. And in particular, when one thinks about letters of intent, more often than not, you've got a cap as to what work are to be undertaken or what value is to be expended. And therefore, there cannot possibly be a completion date because you're not to complete anything. You're only to do certain elements. Now, where there is no completion date, the obligation upon the contractor, both under the common law, case law, and under the Sale of Goods and Services Act, is that you have to complete within a reasonable time. The term reasonableness has come from case law, the wagon mound, and it applies to a lot of things. If you fail to state how much you're to be paid a reasonable amount. So similarly, if you haven't stated how long you've got to do the works, you have a reasonable period of time. I can hear you asking, but what does that mean? What does a reasonable period of time actually mean? And we've got some assistance here in Hick versus Raymond, and where the court said that it is so long as such delay is attributable to causes beyond control and that the contractor acted neither negligently nor unreasonably. So in other words, they'll look at the contractor and say, well, was there exceptionally adverse weather conditions? Were there problems with stats? Events which are not the contractor's fault. In effect, the contractor gets that period of time to carry out the works. When determining what is reasonable, it's based upon the actual circumstances that arise. So let's just say you're in a situation where, for whatever reason, time is at large. What the courts will do is to say, what would a reasonable contractor in the same circumstances have completed in? Is there anything we can say that the current contractor has not done, which a reasonable contractor would have done? It is not enough to say, well, ideally we wanted them to finish much earlier. They should have worked through the night. They should have tripled their resources. They won't do that. They'll just look to see what another reasonable contractor would have done in the same circumstances. Proceed regularly and diligently. That's a difficult one, this is. Absent an express clause in the contract, as in Leander versus Mullally, they confirmed that there was not an implied duty to proceed regularly and diligently. In other words, the contractor had an end date, he had to achieve that end date. He doesn't have to proceed throughout the duration regularly and diligently. All he's got to do is to complete by the completion date. And therefore, if he chose to, he could do no work for the first 20 weeks, and for the last 10 weeks, do all of it. That's what he could do. That's why quite often contracts provide with reasonable to complete with due diligence or to proceed regularly and diligently. And as far as they're concerned on that, they said they are to work industriously, assiduously, efficiently, and expeditiously. Difficult words to pronounce after a beer. But what does that actually mean? And the best advice I can give to you again is, what would a contractor reasonably do in the circumstances? It does not mean that you have to double your resources or work weekends or work overtime. It is to proceed as a contractor would reasonably do, in effect, not expending much additional money. You should not be incurring further costs than you were obliged to do under the contract. The term of the essence means that it is of the utmost importance. It is, in other words, a condition under the contract and not a warranty or an innominate term. Now, those of you who have attended my courses on termination will be aware that under a contract, where there is a breach of a condition, there is an opportunity, if you so choose, of terminating. Where a particular term is breached, which is a warranty, you cannot terminate. Now, certain clauses within the contract, depending upon the circumstances, can either be a condition or a warranty. They can vary. And therefore, we have this other term, which is innominate term, which sits in between them. It means a term that, depending upon the circumstances, either could be a condition or it could be a warranty. And I'll give you a prime example. Payment. If a party fails to make payment of an interim payment at the first month, that will generally be a breach of a warranty. In other words, the other party cannot terminate. If, however, the party refuses to pay at all for the whole of the contract duration, that's going to be a breach of a condition. It's fundamental. They're showing they have no intention to pay, and therefore it will be a condition. So payment is generally an innominate term, and depending upon the circumstances, it can entitle to a party to terminate where it's deemed a condition. Now, as far as time is concerned under a contract, they are generally construed as not being a condition. In other words, a failure to complete by the completion date will normally not allow the party to terminate for breach, and the other party must be given more time after the completion date in which to complete. And the reason for that is more often than not, contracts are deemed that time is not of the essence. For example, the contract provides for liquidated damages. If time is of the essence, it means you mustn't be given any more time. Why would you therefore allow for liquidated damages when that situation ought not to arise? That's why nearly all contracts, time in construction is not of the essence. However, there is nothing preventing you in making time of the essence. You need to have the whole contract indicate that that is the situation. So, for example, there should not be any liquidated damages. It should simply say it is a condition of this contract that time is of the essence and the contractor must complete within 12 weeks. Should this not occur, there'll be termination, so on and so forth. Now, you can, where time is at large, turn that contract into the essence. In the case there is Rickards versus Oppenheim, which is all to do with the delivery of a chassis of a car. There was no stipulated time in the agreement, and Rickards, I think it was, were very upset that the car chassis was not delivered and there was ongoing delay. So they eventually wrote a letter saying, we must have the chassis within the next 2 weeks. Time is of the essence. The period of time that was given was reasonable. They'd made it clear, and by issuing that letter had made time of the essence. Because the other party did not deliver it in such time, they were entitled to terminate and seek damages. So under a construction contract where time has been rendered at large or is at large, you can nevertheless make it of the essence by notifying the other party. Now, for those of you who have been on my damages course, you will be aware that I am of the view that having liquidated damages in a contract is a great benefit for the employing party. I've been involved in many claims for loss and expense, and it is extremely difficult to deal with causation, proving that a particular event caused you to incur a particular loss. In some projects, it can be almost impossible. And that's exactly the one that dealt with the cases of the liquidated damages. It all concerned a submarine. Contract was for the construction of a submarine, strangely just before one of the world wars, and unfortunately it was not constructed in time. The purchaser of this submarine took legal action and claimed liquidated damages for late completion. The manufacturer, the organisation constructing the submarine, sought to avoid damages, saying that it was a penalty clause and liquidated damages should not be applied because they could not be proved as a genuine reasonable pre-estimate. The courts refused. They said that in cases where there was difficulty in assessing what the true loss would be, liquidated damages is an appropriate way of dealing with it. So, on that basis, there is great benefit of having liquidated damages in a contract. The alternative is general damages, which is what you have to prove. Now, the problem is that where you have liquidated damages, if the employer anyway seeks to prevent the other party from completing, the contract must have provision for extension of time, because if they don't, time and the damages will be rendered at large. That is why all these contracts have provisions for extension of time. It is to maintain the mechanism for the completion date and the application of liquidated damages. And it's called the prevention principle. If you don't have the provision for extensions of time, time is rendered at large because the liquidated damages clause becomes a penalty. Now, the courts are far more reluctant in recent years to find that time and damages are at large, and will look to maintain the contract completion date and the damages provisions, but they still nevertheless do fail for a number of reasons. Now, to give you an example, the NEC Edition 1 didn't have a fallback delay event for certain events. If you look in the later edition, it says for any other breach by the employer. The reason that was brought into the NEC was to prevent time rendered at large. Now, in various contracts, what you do is you have this catch-all clause. This deals with any failure by the employer and hence will prevent damages and time being rendered at large. Now, other contracts, JCT, NEC, have a number of events. Certain events that relate to the failure of the employer are required to be in there to prevent time being rendered at large. And let me give you an example. Under the JCT, we have a clause for deferred possession. Unfortunately, it takes a lot of time quite often to get a project underway, and sometimes the date for possession in the contract cannot be met. So what we have under the JCT is a provision that says in the event that possession of the site is to be deferred, the contractor shall be entitled to an extension of time. It thereby stops time and damages being rendered at large. However, the JCT provides that that period of deferment shall be a period up to 6 weeks. So what happens if there is a deferment of 7 weeks? Well, the end date is clearly delayed by 7 weeks because you can't start the works until you've given possession. You've been delayed by 7 weeks. The contract only permits an award of an extension of time of 6 weeks. And therefore, the contractor, in theory, is going to be culpable for a delay of 1 week, notwithstanding it wasn't his fault. That is exactly a situation where the time mechanism under the contract has failed because of the prevention principle. The contractor has been prevented from completing the works by the employer, and now the mechanism for time and damages has failed, and time has been rendered at large. So that deals with clauses in regards to employers' failures. What we now need to look at is neutral events. Now, the JCT and NEC both include events for neutral events. They are events which are neither the contractor's fault nor the employer's fault. Force majeure being one, and which is often discussed, not unsurprisingly, in relation to COVID. It was neither the contractor's fault nor the employer's fault that COVID occurred. And therefore, contracts provide potentially for an award of an extension of time for COVID. But to be force majeure is something that neither party was aware of. So in the case of COVID, you would only be able to rely upon force majeure if you entered into the contract before you were aware of it. So it would have to be a contract that was entered into something like before January or February of last year. But we have other events, exceptionally adverse weather conditions and statutory undertakers. Now, because these are events for which the contractor is not responsible, nor is the employer, you can actually delete them. All that has happened is that the JCT or the NEC have decided that these risks are quite onerous, and they've tried to decide who is best one to take that risk. Now, under exceptionally adverse weather conditions and force majeure, under the JCT have thought the risk for time should be with the employer, and hence there is an award of an extension of time. But the cost risk should be with the contractor, and hence there is no relevant matter. By contrast, however, under the NEC, you will be aware that for all compensation events, there are time and money. So under the NEC, the employer takes the risk for these events, both in terms of delay and loss and expense. But it is possible, there's nothing preventing it happening. You could delete all of these neutral events and time would not be rendered at large. Okay, this is one that all too often comes up. I remember my days in construction. This probably will not come as a surprise to those who know me, is that my director would come down to site and say, Richard, you're extremely aggressive. Every time there's a delay, you put in a relevant event notice and you put a loss and expense notice. And I have noticed that you always do it a Friday afternoon at 5 o'clock. You know, you're not creating good relationships with the employer. What I want you to do is to do it far more softly. Don't worry about these notices. I remember those days all too clearly. And what I found in the days that I've been a legal consultant is that quite often when I speak to contractors, they say to me when there is a delay and there is a dispute, well, you know, we're not claims orientated. We're not that sort of nature of business. We simply didn't submit extension of time or loss and expense notices. We just didn't do it. Or they say, well, we spoke with the employer and the employer said to us, you know, don't send notice in, don't worry, you can trust me, I'll look after you. So my advice is do put notice in, and I'm going to tell you how to do it easily and effectively. But the question is if you don't put a notice, are you still entitled to an extension of time? And the answer is, it depends. And it depends upon the contract. So if you look under the JCT, it says that you shall, as soon as it becomes reasonably apparent, give a notice. What it doesn't say is how long you've got, nor does it say what happens if you don't. And following the case of Bremer, it has been decided that under a JCT form of contract, the issue of a notice is not a condition precedent to entitlement if you fail to issue it immediately or as soon as it becomes reasonably apparent, because that is not what the contract provides. However, let's look under the NEC. The NEC by contract sets down a very clear period in which you've got to issue a notice of a compensation event. being 8 weeks when you were aware of or ought to have been aware of the event. It then says what happens if you haven't, and it says you have no entitlement. So it is meeting the express requirements of Bremer, and hence under the NEC, the issue of a compensation event notice is a condition precedent. However, there is one exception. The NEC goes on to say that where the project manager should have issued a compensation event, the contractor does not lose their entitlement. So the question is, for which compensation events is the project manager obliged to issue a compensation event notice? And the answer is in regards to the issue of all changes to the works information. In other words, all instructions. So when you're under an NEC, what should the project manager do? They should issue the necessary instruction. They should issue an early warning notice. They should issue a compensation event notice and, in theory, a request for a quotation. Where they fail to issue a compensation event notice, and similarly, so does the contractor will not lose their entitlement. What the courts have also said is that they will not interfere with clearly drafted conditions. Now, I have seen some horrible clauses in contracts where it is a particular contractor and they've drafted their own bespoke clauses that say something like this: the contractor shall issue notice of any event within 1 second of becoming aware of it, or not much longer than that. And the question is, well, that's unfair. That's completely unreasonable. And the answer is hard luck. Court said they will not interfere where they are clearly drafted. So for bespoke provisions, where you see there is an obligation to issue things within a set period of time, clearly set out, and it says if you fail to do so, you shall lose your entitlement, that clause will be enforceable upon you. So you need to ensure that you give good notice. Quite often, however, the parties do not follow the terms of the contract. Dare I say it, in most disputes I get involved with, I find all too often that both parties have not followed what the contract requires. Now, where you have failed to issue notices, there is opportunity to argue that that requirement has been waived, or that the other party is estopped, prevented for relying upon that clause. So what is waiver and estoppel? Well, basically, it's where the other party has in some way told you or indicated to you, or by their actions inferred to you, that they didn't require you to do something. Where you can show that you have relied upon that to your detriment, then you can say that that requirement has been waived, or the other party is stopped from relying upon it. So in situations with regards to notices of extension of time, where the other party has told you not to issue notices, or has requested that you don't do so, or has indicated that they no longer want you, you can rely on this nature of defence. Okay, now, a number of times I've seen letters for contractors where they have claimed an extension of time. They've particularly looked at the contract, for example, a JCT, and have noted that there is a period of 12 weeks in which the architect to award an extension of time, but the architect has simply failed or has wrongfully rejected the extension of time. And the contractor has then gone on to say, well, because you have either wrongfully rejected or you failed to respond within a set period of time, time is now rendered at large. And I'm afraid that's wrong. Where that situation arises, where there has been a failure to award an extension of time in accordance with the mechanism under the contract, there is a way around it, and that is for the contractor to refer that dispute to adjudication or arbitration or litigation, and to have the matter considered, and where an adjudicator, an arbitrator, or a judge can award that extension of time, and hence time under the contract, the mechanism for time has not failed. So that's the option number one. The second option is where there has been a refusal, potentially you can terminate on the basis of a breach of a condition. But my advice to you in these sort of situations is where you find yourself not being awarded an extension of time, there's nothing more you can do, is to consider adjudication, but do not consider that time is rendered at large. As we've identified, where there is a failure to complete on time, there will generally, but not always, be damages. For example, where there isn't, in Temlock versus Errol, damages were stipulated as nil, and therefore not only could the contractor or the employer not claim general damages, nor could they complain the liquidated damages. Where there is a failure to complete on time and it goes on for such a period of time, then there is also a right for termination. Right, we're now going to get into the crux of the situation in dealing with delay under a contract. So, just to repeat the starting point, it depends upon the terminology of the contract on what your entitlement is. Under NEC, it is the difference between the last accepted program and the current accepted program. But under JCT and most other contracts, it is what is the delay caused to the completion date. I have been involved in, I don't know, hundreds, if not thousands of disputes concerning extensions of time. I have acted as an expert witness in dealing with extensions of time. I've acted as adjudicator, and I've acted as representative both in advancing claims and defending them. And let me tell you, every time it will go down to who has the best records, who can show what actually happened or what did not happen. Many contractors' claims fail because they can be shown not to be true. However, if they're the only records that exist, you can't disprove them. But what you're meant to be doing is you're meant to be showing what should have happened if everything went to plan, and show that that could have happened. The next thing is to show that events occurred that prevented that happening. What happened, why, when, and how did it ultimately affect the completion date? What you then need to show is that the event is the other party's responsibility and the relevant notices have been issued. It seems very simple, but it isn't. And we're going to look into a bit more detail about how to go about it. What we've got here is that in order to establish entitlement, we have to show that the relevant event we're relying upon actually caused a delay. We then need to show what was the effect of that delay, and then show that we used our reasonable endeavours to prevent further delay and seeking to mitigate that delay. And it's all based upon evidence. And as you will have heard in my last week's course on Waterloo, you can use whatever evidence you like, including witness statements. The question is what weight will be given to that evidence? Basic rules. It's very difficult to argue about a photograph. It's far easy to argue about what one person says was white when you say it was black. Okay, within the notes, I have gone through in some detail various methods of proving delay, and I will leave you to look through those. But I'm going to address two main ways of doing it. The general way that is being done and the best way, in my view, of doing it. So let's start off with the common approach. Quite often, what a contractor does is they produce at the beginning of the contract their baseline program. Quite often it's indeed called a contract program, when in fact it is not even a contract document. So it's not a contract program, but a construction program. And what a contractor does is they set down this program showing what should have happened. What they then do is to produce another program, which they overlay, which is called the as-built program. What it shows is all the same activities, bars, but much longer periods, possibly some of them starting much later, and they show the end date. And they then say, there you go, I've proved it. There's the actual program, there's the plan. Difference between the two is the award of extension of time. Please give me. Now, the problem with that is it is very difficult to exactly establish what was the delay. Now, the starting point is the original planned program often is not followed from day one, so it is the wrong baseline to compare with. The second thing is by looking at the as-built, it is not possible to see the links between activities. The reason for that is no building site finishes one activity before they start the next. You don't build all the brickwork before you plaster. You get a certain amount of the brickwork up, let's say, and then you start to plaster other bits. Or you work in a sequence. You don't pull all the foundations first before you start the drainage. You will do bits of drainage, bits of foundation. So there's always an overlay between when one particular activity starts and the next one starts. Now, that's simply something we cannot establish when looking and comparing the planned against the as-built. If I say you, can you please show me where you were 60% complete on a particular activity? On an as-built, you can't do that. And you can't deal with concurrent delays. It's very difficult to actually establish what the delay is when simply producing the original planned programmed activities and the as-built. Now, there's no harm in attempting to run an extension of time on that basis, but it has its difficulties. Now, my view is this is the best way of dealing with delay. So we're going to start off first of all with your program. And basically, both as an employer and as a contractor, that program should be continually updated to reflect actual progress on site and the actual planned intent going forward. Now, it is open to the contractor to take advantage of that situation. And what I would suggest for the contractor's benefit is as and when you update the program, you always show yourself being on time. Now, the reason for that is if you show yourself being 1 week in front of program, and then there is a delay of 1 week, the other party will say there was no critical delay because you had float. So you should never be in front of program. Equally, if you show yourself being 1 week behind, and at the end of the job you finish 1 week behind, and you claim extension of time, the other side will say, no, the delay was always due to yours because it was the first critical delay. So you should never show yourself behind program unless you can blame it on the other party. You should always be on program. So what I will be doing is effectively what the NEC requires. I shall produce a program, and every month I shall update it by showing a time now line. And a time now line is a line drawn showing the percentage complete. So activity number 1 is 30% complete. So I draw through the bar 30% complete. Next activity is shown as being 20% complete. So I draw a line 20% through that bar. And therefore there is this line going through all the activities. If you pull the line straight, it will effectively show you the end completion date or whether it is in front of program or behind program. And what I'm saying is throughout the process, I will adapt and amend the program to show myself always on program. What then happens in one particular month, I find myself falling behind. And I say that the reason for the delay is the other party. So therefore, I keep the logic as it was before, show that that activity is behind, and hence it will show that the completion date goes out. I can then identify what was the cause, that event, when it occurred, at that date, and what was the impact on the program. And what this is, in theory, is either a time slice analysis or time impacted analysis, 2 and 3. There's not much difference between the two. A window analysis is generally that you're doing the analysis in a window, for example, at the end of the month. More often than not, window analysis is used where people are using their progress reports issued for monthly progress meetings. Those are the records of performance on site, so we have to produce our programs on that date, and therefore it is a window within a window. Time impacted analysis is slightly different. It is where you had the relevant information on the date the event impacted the program. And that's what's going to happen in theory under NEC. Because under NEC, as soon as you get an instruction, which you say is a compensation event, you're meant to submit a quotation. With that quotation, you should be submitting the program where you say the delay is going to, where the works are going to be delayed. And thereby, the program you produced is not produced in every month, but is instead issued when the delay impacted the program. Now, to me, this is the best method or means of showing delay analysis. It is the most important and easiest way for the contractor to do it. And it's easy enough to produce, and even, dare I say it, for the employer not to potentially know it. When you issue your progress reports each month, what you should be doing is giving your percentages complete. And by so doing, you are recording where you are on program, and you could actually impact a program retrospectively if you choose, or indeed produce it, maybe not even issue it if you choose to, and keep it in a file. You're creating a whole set of records. It's the only records that exist, so it is the best records. And you've got the program showing the knockout. If you then add into the progress report some narrative explaining what the problem is and why, you've dealt with causation as well. And then if you want to tick the final box, is maybe to include some photographs that evidence and support what you're saying. To me, that is the easiest and best way of dealing with delay, and is also the way required under the NEC. Now, I do emphasize under the NEC, it doesn't say produce photos, but that's what I would do. I'd be including photos. The other situation that happens under the NEC is all too often these programs are not accepted, and the other party gets frustrated, so they stop issuing them. That is a big mistake. Under the NEC, if you're the contractor, keep issuing your programs for acceptance in the format required by the contract and identifying the delay. And the fact that they are not accepted is irrelevant because they are the only record that exists. Okay, so to go through a summary of a situation. It is possible under certain contracts that the issue of a notice is a condition precedent to entitlement. So in other words, if you do not issue a notice, you lose entitlement. An example is the NEC. JCT, unless there are bespoke amendments, does not require a notice to be issued. You are still entitled to an extension of time when you've issued no notice at all. Such entitlement arises 12 weeks after PC. Contracts must provide for extensions of time for the employer's fault. If it doesn't do so, time will be rendered at large and the liquidated damages clause will fail. I gave you the example of a deferment of 7 weeks under a JCT where there is only an entitlement to 6 weeks extension of time. Generally, I would suggest to contractors that when having a program, you update it to always show yourself either always being on time, where you are behind time because it's your fault, or maybe even in front of program. Because I do feel that your entitlement will be reduced because of an analysis. So be on time. What you should then do is each month with your progress reports, be producing in effect a time impacted analysis. What you should be doing is showing percentages complete for all the activities on the program, or indeed just issuing the program with percentages complete on it, so that you can actually identify what are the critical delays each month and what is the driving activity to completion and what is the delay. By issuing that nature of information, you are likely to satisfy the requirements for issuing notices as well. Within the progress reports, you should be identifying and giving narrative for the reasons for delay and explaining them. And it's also useful to include within it programs. Do you have to issue this through the project? No, the JCT says very simply, you have to give notice, you have to give an estimate of what you assess the delay is, you have to give an indication of what you think the delay is, and that should include for your own delays as well. That is the requirement for a notice. But if the other side does not award you an extension of time and you have to go to adjudication, then I'm afraid your obligation is to prove your entitlement on the balance of probability. In other words, to a 51%. The manner by which you can assess that delay is down to you unless the contract otherwise provides. So under the NEC, it does. But under the JCT, you can use any form of retrospective delay analysis that you choose. When reviewing that delay analysis, an adjudicator, an arbitrator, or judge will review it to A, make sure they understand it, and B, make sure that it is not purely theoretical and actually reflects what actually went on. It is the easiest way to undermine the delay analysis by showing it's simply not true. I hope that's been of some assistance. Julie, are there any questions?
There are indeed, Richard, there are indeed. Someone's asking, how can you effectively and clearly show cause and effect from supplier lead times, which are often verbal and or outside a contractor's control?
Right, well, whenever I was in construction and I could see there were large lead-in times, the first thing I would do is I would look at the nature of the contract, and more often than not, the lead time was at my risk. So I'm going to order some windows, there's a design period, there's a manufacturing period, there's a delivery period. I'm actually going to show each and every one of those on my baseline program. So everything of that nature is on a program I generally produce. I did not simply produce the information to do with the site actions. I would also show information that was off-site. So thereby I could show that, for example, the issue of an instruction on an expenditure of provisional sum had to be issued by a certain date to allow for that whole procurement period. So very simply, in answer to the question, make sure you show it on your program.
Okay, someone else here is asking, how much time is the contract administrator allowed to rely on to an extension of time? For example, can the contract administrator not reply to an EOT for months and then reply and reject the EOT a week before practical completion?
Answer to that is depends upon the contract again. Under the JCT, for example, that the CA architect has 12 weeks from receipt of the request, or if later from receipt of necessary particulars. Now, the problem with that second part is that all too often architects ask for endless amounts of information and you can never satisfy them. So they can, in effect, do what this person is asking. But what actually happens is let's say we're on a project and that's what's happening. You have a choice as the contractor. What you can actually do is to say, I think I have given you sufficient information and you failed to do so within 12 weeks. If that arises, then your right is adjudication. You would go to adjudication and saying, they had 12 weeks. Yes, correct, tick box. They ought to have awarded an extension of time. They haven't, tick box. What is our true entitlement? 6 weeks, tick box. So that's what you can do under the JCT. The NEC is slightly different. It is far more prescriptive. You've got the added situation where the project manager doesn't respond within the time of the quotation, is that in itself becomes another compensation event. You can claim more extension of time. But where the project manager fails to so respond is exactly the same, off to adjudication. I'm afraid that's all you can do.
Okay. How would you suggest showing COVID-19 related delays if the impact is not known till delivery or installation on site?
Depends upon the contract. JCT says that what you do is you give particulars within your notice and you can update it. Under JCT, if in your first notice you say 3 weeks, you're not stuck with 3 weeks. You can have as long as you like. So under JCT, you would say that we currently assess 3 weeks, but this is based upon the following factors or presumptions or assumptions. And then when those assumptions prove wrong, you give another update. We had anticipated this being delivered by such and such a person by this date. It hasn't happened because of the ongoing problems with COVID. We now assess it's another 3 weeks, but we'll advise you if this proves wrong. So you can constantly update the information. NEC is different. NEC says you cannot include any assumptions. But with COVID, it's a very difficult thing because is COVID one event or a number of events? Now, this happened back in January 2020, and we've still got it. Are all the delays and the new lockdowns one event, 2 events, 20 events? I don't actually really know the answer because it will depend on how you view it. But in those situations, what I would do is, you could do this. At the moment, we assess that the problems with COVID will take another 2 years, unless you as the project manager will make an assumption. If you then make an assumption, I'll update it. But under NEC, you're under a far greater risk in being fixed with what you assess. So on that basis, include your risk and make it huge. And then the project manager is left with no option but to make an assumption. He says, I assume that lockdown will come to an end in January. If it proves not to be the case, that becomes another compensation event.
Okay. Someone is asking, as the client, how can we cover ourselves against an EOT?
Not issue any instructions, not vary the works, and not delay the contractor.
Simple.
Now, it's easier said than done. I think there's 2 questions here. Question 1 is, how do you not give an extension of time or cause an extension of time? The second is maybe as a question is how to avoid more claims of extension of time, or how to avoid spurious claims for extension of time. And what I would say in that regard is, if we're looking at the JCT form of contract, you need to amend it. Now, all too often, employers go out to solicitors who ask to amend the contract. But what the solicitors do is to amend the risk profile. So if we're looking at a design and build job, they say that the design is the total responsibility of the contractor. They say that the contractor will take responsibility for all the design undertaken by the employer and prior to the appointment of the contractor, and so on and so forth. What they don't all too often deal with is procedures. So I would put things in like this. The contractor shall issue, within 3 weeks of commencement on site, a fully critical path program. The program shall show all links between activities and all float. The contractor shall show when the expenditure of provisional sums are required and a reasonable period for all provisional sums. The program shall include float. This is what the NEC already does, but I'll be setting down what the program should show. I would then have something along the lines of, similar to the NEC again, that the contractor shall produce at the end of each month a revised, updated program showing actual progress on site, percentages complete, areas of problems, problems of delay, and all this, and loads of information. And I would put something along the lines of, a failure to include or to issue this information will mean that 10% of amounts due in interim payments don't fall due. So I've got a financial penalty if they don't comply. So now they are complying, and every month they're issuing a program. Now, I've been on jobs, and throughout the job, everybody said the job was going fine. And then when the job finishes late, suddenly they're creating all these delay events that at the time weren't even raised. But by doing what I'm suggesting, you can actually, at the end of the meeting, say, I've got your program here, let's walk round site. Okay, you're saying this is delaying you. It's not, is it? And take a photograph. Because look, you aren't progressing this other activity and it's not causing a delay. So I, as the employer, can deal with the delays at the time they are arguably arising. And the contractor is less able to manipulate the facts. So in answer to the question, I'm going to amend the contract to include for monthly issue of programs in proper detail, and then I'm going to review those programs each month and to record that there are no delays on site.
Okay. For NEC contract, if the contractor submitted a program with, for example, 6 weeks delay, but the project manager disagreed with that and is requesting the contractor to submit a revised program with a shorter delay period, what can the contractor do?
The contractor can simply say no because it's not possible. Or alternatively, he can say, yes, it is possible, but it will resequence the works and which will incur substantially more money, and hence my quotation is now just double.
Right. Okay.
The alternative is that the project manager says, I don't agree with it because I think fundamentally the delay you're showing is wrong. What he should do is he should reject the program and say he's going to assess it himself, and then he produces his own program of what he thinks is the true delay.
Okay. A question here on the level of evidence required to prove an EOT claim. Can the client's team ask for messages, emails to all the contractors, suppliers, subcontractors, or even third-party correspondence?
You can ask for what you get, like whether you'll get it is another matter. The point is that what a contractor has to do is to prove to 51%. And if the evidence they put forward is sufficient to meet the 51%, they don't need to do any more. Now, quite often, more with loss and expense than extensions of time, the information is requested. You know, for example, wage slips and things, and then the contractor says, I'm not too keen on providing it because of data protection. Doesn't happen so much in regards to extension time, but I recognise it does sometimes, basically because they are, you know, maybe hiding something. So if you're saying, for example, you know, the window manufacturer said it was 6 weeks for delivery, you know, because of this late information, you think it's 5, you know, you can request that information. If the contractor refuses, then you can put the evidence of weight on him that he's not telling the truth. So actually, sometimes you're better off not to get the information, is to ask for it, not get it, and then say to the adjudicator, look, you're not telling me the truth.
Okay. Someone else is asking for clarification on where does it say in the JCT contract that the contract administrator must respond within 12 weeks? As far as they're aware, the contract administrator has up to 12 weeks after practical completion to give a final EOT award.
That's only the final award.
Right.
So the final award is it says the CA shall, 12 weeks after PC, whether an extension of time notice has been issued or not, consider what entitlement the contractor has. So that is a final review and it has to be done whether any notice has been given or not. However, elsewhere in the contract, it says upon receipt of a notice of extension of time, the architect shall consider that extension of time request or from receipt of sufficient particulars and shall have 12 weeks. So there are 2 separate provisions. The one they're referring to is only one. They've not seen the other.
Okay. That's what happens when you know that contract inside out. You're able to quote. Someone else is asking, how do you notify loss and expense?
As is the answer in all my talks, it depends upon the contract. Loss and expense in regards to NEC is part of your quotation. Your only notification that is a requirement is the compensation event notice. Once you've done that, you've done the notice, it's then a measure of quantity. Under JCT, it is a separate notice. You know, all too often, this is how notices go. Dear Mr. Architect, it is with great regret that we hereby give notice that the works have been delayed by a relevant event. And it's the first time contractors ever use words like hereby. They start using these words unnecessary. They then go on, we are not at present able to fully estimate the delay. but will of course give you full and better particular once we know. That's non-compliant as well. It then goes on to say, we will do every effort to mitigate delay. And whilst writing, we also claim loss and expense. That is woefully inadequate. So what you have to do is you simply have to notify. So, dear sirs, we would advise you that on Monday the 3rd, we requested the following information. We requested within the RFI that the information be provided within 7 days. 7 days has now elapsed and we still don't have that information. The consequence of this lack of information is that we are now in a standstill with regards to the following activities, and which is having a consequential knock-on effect to the critical path and ultimately the delay. Whilst we are still waiting this information, at present we can assess that there is at least 1 day's delay if we receive the information tomorrow, but the delay is obviously going to be far greater depending upon when we got the information. The rule I've generally given to contractors is this. If you have a delay notice, you should be able to give it to your mum, and your mum says, I understand what the delay is and why. If they don't, you're not doing it. And you've got to, people say to me, yeah, but the architect should know. Yeah, he does know. He knows it's his fault and he wants to ignore it. So that's why you need to have better records. Because dare I say it, quite often the person who is reviewing your entitlement is not independent. The next thing is use photographs. It's a great benefit. So I would be issuing a proper narrative explaining what's going on with photographs. Okay. As far as loss and expense is concerned, what I will be doing is going further. So following the extension of time letter, following our letter of extension of time, you will note that we are currently incurring a 1-day delay. The effect of this is I've now got 6 carpenters standing with their trowels, carpenters, with their saws, drinking cups of tea and doing nothing. There's therefore that cost. I've got my prolongation cost, which means I'm likely to be on site for another week, which will be all of my site setup and et cetera, et cetera. There is also likely to be return visits to these areas involving this, that, and the other. Again, what you are looking to do is to tell a story. Explain what is going on. Now, the other thing is where you're involved in a really, really big project that is going really, really bad, the same thing always happens. I get involved and someone calls me and says, can you come down to site? So I go down to site and the job should have been finished 6 months ago, but still incomplete, huge dispute, and they're asking for assistance. And the same thing happens. I go to the person on site and say, okay, I've been instructed to look into this delay analysis and to try and assist you on that matter. Can you answer the following questions? And the person always responds the same. He always says, sorry, mate, I can't help you. I've only just joined. Everybody else has left. And that's what always happens. So what you need to do is to keep the records at the time they occurred and to be telling stories in your letters. Use bullet points, clear and simple, and photographs.
Okay. Can the client request a complete breakdown of the claim, including the percentage of profit applied for the extension of time from the contractor, and subsequently the client disagrees with the amount of profit percentage being claimed upon receipt of the same?
Yes, simple answer to that. Dare I say, I know that contractors will take exception to this, but sometimes I've found contractors claiming profit that isn't a true reflection of profit. If you're a PQS, I would ideally ask for a full tender breakdown, including identifying the profit at the start of the job, if not even as part of the tender. But if you haven't got that information, everything is being retrospectively done. Now, it's quite often, with good reason, PQS and the contractor may, as the job progresses, agree a percentage for profit, not uncommon 10, 12.5%, whatever, but it doesn't always actually reflect what the true profit is. Now, if a contractor is claiming for a loss of profit, they've got to prove it. And they've got to give all that information in support. So in answer to the question, yes, you can ask for it.
Okay. One final question here. What if defined provisional sum is not technically correct and lacked information at tender, and later in the contract it proves to have a much longer time than estimated at tender?
Okay. For those of you who aren't aware, the contract provides for, the SMN7 includes provision for defined and undefined provisional sums. And the significant difference between the two is that a defined provisional sum will have information within the contract documents that enables the contractor to program for it. So it will show where it is, how much of it is. So let's just give an example. Asbestos removal. It should say it's blue asbestos, there's 10 meters squared of it, and it's in the kitchen ceiling. If you've got a provisional sum that says asbestos, provisional sum, 20 grand, and you've got no information about it, it's not a defined provisional sum. It's undefined because you don't have the information. Now, according to the SMM7, where you have an undefined provisional sum, the contractor has not included the programming, planning, or prelims. So this activity should not be shown on their program at all. And any cost associated with it, including prelims, are recoverable. Now, to overcome that problem, some people, PQSs, within a BFQ, despite only putting asbestos removal and no more information, then say this is a defined provisional sum, when in fact it isn't, because it's undefined. And in other words, what we're saying is the BFQ has been wrongly drafted. If one looks at the JCT, it says there's a clause that the contract has priority over all other documents, and which would include the BFQ. And it says that where there is any conflict between the BFQ or any other document and the contract shall prevail. Now, the contract says that the contract and the BFQ has been measured in accordance with the SMM7 when it hasn't. So we've got a conflict between the BFQ and the contract. The contract prevails and now it's undefined.
Okay. And then just a quick one finally. I know you have covered this before, your route, but someone's asking, how do you become a construction or property lawyer coming from a QS background, and would you recommend making this transition?
Okay, how did I started off as a QS. As a QS, I was horrible and obnoxious, argumentative, difficult, and everything else. So clearly, being a lawyer was a natural progression. I worked on many sites, was not particularly popular, and could think nothing more fun than sending stroppy letters on a Friday afternoon. What as a consequence happened was that I found myself constantly being put on jobs as a troubleshooter. So where a job was going particularly wrong, I would be sent down there to sort it out, and I would take over the whole management of that work, both doing the contract management and the surveying. Now, I had an interest in the law, and as a consequence, whilst working on site, I actually did a law degree. I completed my law degree, and what I found was I dealt with lots of disputes. I had a bit of a reputation, and I found a number of subcontractors and others asking me to assist them. And as a consequence, I then left working as a traditional contractor and started up what was then termed a claims consultancy. Having started the claims consultancy, I then decided, having done the law degree, to do the bar. I then transferred and did a course to become a solicitor, and then set up my own solicitor's practice, and then moved into other areas, including adjudication. So that's how it happened. Would I recommend it? Yeah, no reason why. The biggest problem is it takes one hell of a long time. And lots of people might not want to do it. The other problem is if you are a senior manager or a senior surveyor in construction, being perfectly honest, they're paid quite well. And if you're going to move into acting as a solicitor, as a claims consultant, you are starting your role at a much junior level, and quite often it's a big pay cut. I've spoken to many people over the years, And what I've generally recommended is that people consider doing the MSc in Construction Law and Arbitration, which is only a year course, and then being a claims consultant, rather than doing a 3-year law degree, 2-year LPC, 2-year training contract.
Okay, well, thank you very much for your refreshing honesty and frankness there. That's all for this evening, everyone. Thank you very much for joining us. Thank you to Richard for your time and sharing your expertise. As always, if there are any specific questions, you are having specific issues on this topic, please do not hesitate to email Richard silver@silverllp.com. We have no more seminars this week, but we have 2 next week, Insurance and the JCT with John Sharp, and that's Wednesday morning, Wednesday the 24th at 8 o'clock. And then on Thursday, we have our property team looking at current hot topics in the property marketplace. That's the Property Roundup, Thursday night, the 25th of March at 6 p.m. If you'd like a place on either of these, please email me at seminars@silverllp.com. So once again, thank you very much, Richard, and thank you everyone for attending. Wishing you a good evening.
Thank you all.